this is what's important. So what I'm going to tell you guys is in June of 2021, Justin Trudeau made an announcement on June 26th, and he said he would never bring in mandates into this country concerning COVID-19. And I recorded that live. And then in August 13th of 2021, Justin Trudeau in a Scrum Live said that he was going to bring in two federal mandates, one for travel and one for government employees, federal employees. The wording on his mandates were very important because if you read the mandates, but the wording that they used was that they expect government institutions to follow their lead, and they expect private corporations and businesses to follow their lead in mandating that their employees get this shot. And people didn't really ask questions on that. And so on the 13th of August, when he said that, I played both these videos beside each other and my blood boiled. I don't know about you as a Canadian. First question that came to my mind, I started searching all the legal paths on the internet, all the universities, the lawyer talk on the legal validity of these mandates. And I can tell you, I found almost none in 3 weeks. I found one at McGill University, and I emailed that lawyer that was talking about it, and I never got a response. So on September 23rd, I put in this request. And this request, we had to do revisions because, of course, I'm just a Canadian and I'm just asking questions as a Canadian that's about to embark on using the citizen tools. These are tools that we have as citizens to question what we're hearing on the media or what we're hearing from the government itself by asking for the documentation. So on September 23rd, I did this, and it was finally revised by October 27th to down to a very small wording. That wording is as follows. All records, I am requesting all records between December 1st, 2020 and October 6th, 2021 associated with the legality and legal path of Justin Trudeau's announcements August 13th, 2021, and subsequently the implementation of these mandates regarding A, COVID-19 vaccinations for federal employees, and B, travel, domestic and international to and from Canada, not only Canadians. And I excluded different things so that you can narrow down a path. So before we go on, I want to break down this little thing. When you are doing questions to the government, you have to really narrow it down for them. Because what they will do is they will add redundant documents. That's what I call them, redundant documents. So this request was made directly to the DOJ. Because as we discussed at the beginning, before a government program can be instituted, it has to be proven legal. So where do you do that? That's the next question. And where we do that is our Department of Justice is to make sure that our government is also following the law, not just the citizens. And the government parties and even the House of Commons and the Senate. Our Department of Justice is to make sure that things remain legal. So I only asked for documents within filed within the DOJ. The reason why we use specific dates like December 1st, 2020 and October 6th, 2021 is because October 6th was the official date that these mandates were initiated. And you'll notice that my request is before October 6th. So I actually asked them, a month earlier to provide the legal documentation. And when you're doing an ATIP request, they're supposed to help you narrow it down to because you're just a citizen, just using the tools. They have to help you learn. So we narrowed it down to this, and this I thought was very good. Now, what we're going to do is look at the very next document. So if you could scroll down, Jane, to the next one that says ATIP extension retraction.
Has here?
Keep going. Next one. There
Yes.
we go. So now you see this is December 20th, a month later. And what we have is they had placed a 1825 day extension onto my request, citing 480,000 documents. So to me, in my head, I'm thinking, wait a second, December 1st to October 6th, they have 5,000 employees, but they created 480,000 pages. And when they sent this extension to me, they did it illegally. And I knew, as per the ATIP Act, which is law, that they cannot do something illegal. So I put in a complaint, first of all, to the DOJ, the ones that made the mistake, and they marked my complaint invalid. And the DOJ director calls me and says to me, Dana, there is no way to remove an extension. And I tell her it was done illegally and I'm going to teach you how. And she said, there is no process. It's never been done in Canadian history. No extension has ever been removed. I'm sorry. And I said, I'm sorry, but I think you need to be taught how. As you can see in this letter, 11 days after that conversation, or 10 days, 10 days after that conversation, the extension was retracted. And you can see in this letter, they used retraction. They used three other words to describe this. And I'm going to spare you all the emails, but if you scroll down on this page, I have put in all the progressive emails to get to this point on purpose so that you as the citizen can see how they will try to stop you. Okay. And mark your complaint invalid. And you think, okay, well, there's nothing I can do. Um, I am a little bit tenacious. Okay. When I know I'm right, I fight. And that's what Jane does. She knows that she is right about Trudeau for treason. And I know for a fact that they are document manipulating. So when this retraction happens, they didn't want to do any internal investigations on it. And I put in a complaint to the Office of the Information Commissioner. Their job is to make sure that information goes out correctly on government documentation. And they also, I'm not going to use the word police, but they administer the ATIP to all of the other places that have to answer to ATIP requests. So when I put in my complaint to the OIC, it was marked invalid. And for about 5 times, this complaint that I had made about them not following the law was marked invalid. And if you scroll down, you can see this. We're going to scroll down, Jane, just a little bit. Administrator that I had made about them not following the law was marked. You there, Jane?
Yeah, sure. You wanted to go down more?
Can we just scroll down a little bit?
Okay.
And you'll see that it says, oh, not too much. Go back up. Sorry, go back up. There's a little button that says more right at the bottom of that paper.
Show
Show
more.
more.
Yeah.
Yeah.
So confirmation of investigation.
Yeah. So finally, after over a year, I get a email from this investigator, and he he confirms. Remember, they were marked invalid, so he has now validated that there are problems. Once he validated one thing, first of all, this is the confirmation, the first one that you see, and then you see a second confirmation, and then underneath that, you'll see a validation on 5 points. So scroll down just a little bit,
Okay, second.
Jim.
Yeah, here goes. Here?
Yeah, go down to the next one, validation. Yeah. So on the validation, you'll see that they validate 5 crimes that the DOJ is committing. And it goes on for a 2-year investigation. I'm going to spare you some of it, but you can always scroll down yourselves and you will see the 2-year history of the investigation. I put it all on there. I even made a video one time because when this DOJ ATIP director called me, it was against my wishes. In my ATIP request, I had specifically said, I do not want any phone calls. I want everything to be done written in emails. And this is exactly why they do not do that, is because somebody like me might create a website and actually show and be transparent to what is happening. You know what I mean? OIC final report.
This one here?
So here yeah.
Yeah.
So finally, after the 2.5-year investigation, the investigator hands it over to the commissioner, and the commissioner writes a final report. And this report, you can see the date on it. It was the 8th month, 6th day. That's only a month and a bit ago. Okay. So they did not make this public. They only released it to me. So immediately I sent them a request that under section 31, I believe. I could be wrong on that right now while I'm speaking, but I think it's 31 in the ATIP, that you can request the reports from the commissioner be made public under the guise of citizen safety. Now, my explanation in my letters were that because we have to rely on our Department of Justice to make sure that everything is being done legal in the government, then if they find that the DOJ itself is not following the law, this is a citizen safety issue. And they did not like that, by the way. They They're kind of fighting on me on it a little bit. No problem. I'm going to win it anyways. By the way, I don't take their no answers very good. So here we have the commissioner's final report. And in this report, you're going to see on the very first page all of the allegations that I made. And actually, they didn't put all of the allegations in here, but they do recognize it within the report. Because one of the allegations is document manipulation. Now, document manipulation is also in our criminal code. If somebody does it to deceive you, and that includes government employees, it is a crime. It is a fraud crime.
You go ahead, I'll try and look it up and
Yeah.
I'll see if I can get it.
It is in my documents there.
Okay.
So the commissioner final report, if we go to the next pages, we will see, actually, I have it here. So the first page is my allegations. And through each one of these allegations, they talk about their investigation, the investigation of extension of time, and they are very specific on the dates and everything else, which is excellent. And I found she did a really good thing on that. This whole final report is incomplete, though, as far as I'm concerned. The extension of time now, because they put a 5 year, by the way, 1,825 days is exactly 5 years, because they put an extension on and the extension was removed and the file was placed on hold indefinitely. I kept trying to get a hold of the DOJ and none of them would answer. The DOJ director that I had been communicating with no longer had her job. She's gone. Everybody but the inspector had disappeared. They're literally not at their jobs anymore. They don't answer their emails. None of this. This is called the Disappearing Act. And you will get it as you try to use your citizen tools. This happens quite a lot. And what happens in these cases is the people that you're communicating with disappear and they give you somebody new and you have to start from the beginning again. They play dumb, like they don't have a file in front of them that tells them everything. Also, people's attention spans are about 3 minutes. If you can't make them understand something within 3 minutes, they're off on another thing.
I have the section number. Would you like me to state it?
Yes, please.
Okay, it's section 366. That sound right?
Yeah.
3661 states everyone commits forgery who makes a false document, knowing it to be false, with intent that it should in any way be used or acted on as genuine to the prejudice of anyone, whether within Canada or not. This can include altering, fabricating, or tampering with documents for fraudulent purposes. If you have more, okay, that's it.
Okay, so does that make sense? So that if they illegally placed an extension onto a very, very important question, which, by the way, I'm going to tell the people, is that not one lawyer, not one government agency, not one corporation, not one doctor requested these files from the DOJ. The DOJ has told me that nobody asked for these papers, by the way. So we all got told that there was a mandate, and literally all of these big corporations and lawyer firms that are asking you for a ton of money never asked for the proof that they were legalized.
Yeah.
Now, we don't know on whether it's even a judge or a council or who finalized the legalization of these two mandates separately. Does that make sense, Jane?
Well, I recognize that it's a violation of the Canadian Bill of Rights, Section 3.1. Would you like me to read that?
Yeah,
It's the
sure, you're absolutely right.
duties of the Minister of Justice, 3 subbracket 1, subject to subsection 2, the Minister of Justice shall, so no discretion there, he shall, in accordance with such regulations as may be prescribed by the Governor and Council, examine every regulation transmitted to the Clerk of the Privy Council for registration pursuant to the Statutory Instruments Act, and every bill introduced in or presented to the House of Commons by a minister of the Crown in order to ascertain whether any of the provisions thereof are inconsistent with the purposes and provisions of this part, and he shall report any such inconsistencies to the House of Commons at the first convenient opportunity.
Perfect.
Exception. I'll just read an exception because it's so short. Exception is just like somebody wants. Okay, so there's a very tiny exception. A regulation may not be examined in accordance with subsection 1 if prior to being made, it was examined as a proposed regulation in accordance with section 3 of the Statutory Instruments Act to ensure that it was not inconsistent with the purposes and provisions of this part. So basically,
Okay.
there's no exemptions.
Exactly. So, can you scroll back up to the orders?
Yeah,
And remember that this OIC,
here.
it is called the final report, but it should also be called and orders. Now, what I want you to do is go to page 5. If you scroll down, there's a page.
Next,
See
like,
next.
yeah,
Yeah, go to page 5 because what you just read off has a lot to do with this page. Okay, now right at the bottom of this page, you'll see where it says intent to deny access. Now I'm going to read this and keep in mind what Jane had just read. During the course of the investigation, the complainant alleged that there was document manipulation and false information being used to subvert the act. Section 67.1 makes it an offense
oh,
to
do I go to 6
destroy.
now? Do I go to 6 now?
Yeah, yeah,
Just a sec, I gotta get to the top of
uh,
page.
yeah.
Okay, there, yeah,
Now, section 67.1 makes it an offense to destroy, mutilate, or alter a record or direct, propose, counsel, or cause any person in any manner to do such things with the intent to deny a right of access under this act. Now, what she is describing there is the law within the ATIP Act, okay?
yep,
But she does not take the information that I gave her on what you just read, which is called document manipulation in our criminal code,
yeah, yeah.
okay? So then she tries to get out of it. My mandate is to conduct administrative investigations into federal institutions compliance with the Act. Remember, Act is law.
Yeah.
And to draw conclusions based on facts. I am not mandated to conduct criminal investigations or assign civil or criminal liability. Although I can draw conclusions based on facts, I do not have the authority to investigate whether the actions were taken with the intent to deny a right of access under the Act. During an investigation, I may disclose to the Attorney General of Canada information relating to the commission of an offense against the law of Canada or a province by a director, an officer, or an employee of a government institution, if, in my opinion, there is evidence of such an offense, as stipulated in subsection 63(2). While Justice could certainly have handled the processing of this request better, I did not find evidence related to the commission of an offense under the Act in the context of this investigation. So she's trying to say, I'm not an investigator. You're going to have to take care of this in a different way. I could tell the governor general or the attorney general, but I didn't find anything really, so I'm not going to. But right after that, scroll down a little bit,
Okay.
we're going to come to the outcome. Outcome. The complainant is well-founded because Justice improperly placed the access request on hold. And remember, my access request, all access requests have to be answered within 30 days. Okay? That's the rule, the law. If it is not answered within 30 days, then a legal extension must be must be placed. There was no legal extension, as we can see in her own final report. So they have put my my request on hold for over 2.5 years, and that means that it's 2.5 years past its date.
Yeah.
Justice failed to meet its obligations to assist the complainant pursuant to subsection 4.2.1. Justice is deemed to have refused access to the requested records under subsection 10.3. Now, that is also law. They have refused to answer my request. This is where it becomes important, people, and this is why I think that this should be on your media, and even if not on the mainstream media, on your alternative media. But there's a reason why that's not happening. There's a reason why when I went to court, no media showed up. And we're going to get into that right after I read the orders. Because remember, the OIC is now stronger or more powerful than the DOJ in this circumstance. So they can give orders to the DOJ. I order the Minister of Justice to do the following: remove any hold placed on the processing of the request. Provide a complete response to the access request by May 17th, 2029. Now, I don't want you to worry about that 5 years because of the next one. Provide updates to the complainant every 6 months on the progress of processing the access request, and provide interim releases to the complainant at regular intervals if possible. The
What on earth did they put 2029 for?
well, here's where that doesn't bother me. You know why? Because later on in this report, it also, the very next thing is what I'm going to break it down a little bit. It means that the DOJ is to contact me and ask me to narrow down the search parameters on what to receive first. So I'm going to tell you, out of all of this, and this is the reason why so many people headed to Ottawa in personal protest, was because they were not happy with being mandated to do something. And this is the exact document that we needed to ask whether they were legal or not in the first place.
Yeah.
Okay. And nobody else asked. So what that means is that I'm going to narrow this down on our first communication, which is going to be on the 13th of this month. And what's the date today? The
The
9th.
ninth, yeah.
Okay, so within the next few days, they're supposed to contact me. I'm going to narrow it down to the one document that we are looking for. There is no, all of the other documents that they can take their time to get to me till 2029 are supporting documents. Okay? That means the meetings they had, the whatever. Okay, the court decisions or whatever. But I want the final document. I want the document from either a judge or a council or the Privy Council who made these individually legal. Basically, on August 2nd, 2024, the Justice Acting Director of Access to Information and Privacy gave me notice that the Justice would be implementing the orders. Now, I found a problem with this. It says the Acting Director of Access to Information. Remember the lady that signed the the extension and also called me illegally and said that there was no way to remove it?
Yeah.
She was the director. So this tells us that she is now gone and there's an acting director, and they would not name that director in this document.
Oh, God.
Okay. So, but this tells me that they have agreed to implement the orders that the OIC is giving them. Justice indicated that in an effort to comply with the orders, they have assigned 5 members to index the records, and the file will be transferred to a paralegal for review of exclusions, and a senior analyst will take over review of the documents due to its volume and complexities. Now, earlier on in this report, when we passed by page 3 or 4, it tells you that the DOJ told the OIC that they only had one person on this the entire time. That one person could only produce 90 pages in a month. And that's how they came out with 5 years, because now they've narrowed it down from 480,000 documents down to 163,000 or something like that. So this is where the important part is, where you were just about to talk to. Review by federal court. When an allegation in a complaint falls under paragraph 31A, B, C, D, D.1, or E of the Act, the complainant has the right to apply to the federal court for review. When the information commissioner makes an order, the institution also has the right to apply for a review. Whoever applies for a review must do so within 35 business days or the date of this report, and serve a copy of the application for review to the relevant parties, as per section 43. If nobody applies for a review by this deadline, the orders take effect on the 36th business day after the date of this report. Now, I responded to this final, remember the wording, final report, right? But what happens if somebody disagrees with the report? Do you know that there's nothing in the ATIP Act about a citizen disagreeing with a report or having it reviewed? So I refuse. The reason why we use citizen tools is to hold accountability.
Yep.
And if we cannot hold accountability in our government on these very uh, detrimental questions that we are facing these days, then what are we to have faith in? It is bringing the house of the DOJ into disrepute, and that disrepute means that it's losing the faith of the people. That's not what we want. Uh, we want. I personally want you to believe that our system works,
Yeah.
but it is not being used effectively.
Yeah.
I cannot afford, nor do I have the expertise to be putting in for federal reviews. That should be the job of the OIC commissioner and the DOJ themselves.